Welcome back to Contracts Part 2. We're going to deal with, as I mentioned, the general terms and conditions, or what many people refer to as the boilerplate. And as I said in Part 1, in this we often find the devil in the details. Let me start with, and we're just going to do half of the boilerplate today, 1, the contractual relationships, paragraph 1. Now, in this, it talks about an independent contractor. The key here is you as a contract administrator want to make sure that you are not joining forces in some quasi-legal joint venture. There is an owner, there is a contractor, there are subcontractors and sub-subcontractors and even suppliers. They all need to be separate. In item number 2, items to be furnished by the subcontractor, note that this particular general terms and conditions says all items, including labor and materials. And it will go down further and say materials shall refer to and include all substances, supplies, equipment, machinery, apparatus, and other things. When you read this, you need to also go back to that variable part of items to be furnished by the contractor. It said none. Therefore, you might be responsible for the scaffolding. You're going to be responsible for all the equipment. If there is no crane on the job, and no one said that you were going to have a crane at your disposal, you've got it. So recognize if there's special things that you need, particularly something as simple as access during certain hours, you want to make sure that you've called that out before you sign the contract and have it in writing. Now, performance requirements and specifications, paragraph number 3. All the requirements of the principal contract and its specifications and drawings are applicable thereto. You've got it all. Now, what's important here is that you're being charged with the principal contract. Have you in fact looked at the principal contract? Do you know all the situations? All those drawings and all those specifications that were shown in the scope of the work are now part of your contract, even though you may not have looked at certain parts of it. If you're an electrical contractor and they're telling you you've got the mechanical, there may be electrical hookups on the mechanical that are not even shown on the electrical drawings that now you have. So be sure that you've looked at the entire contract before you sign that. In case of conflict, it says, with the drawings, the specifications shall govern. This is a difficult sentence here because there may be within the principal contract a contrary statement. This leads to an ambiguity. Now we go to paragraph 4, change in specifications and drawings. There could be an increase or there could be a decrease, but whether there is a change or not is going to depend upon written notice. Keep aware that you have to provide written notice. This is going to hold you to it because if you don't give written notice, you bought the change and any cost therewith. It will say, notice the matter will be submitted to arbitration if it can't be resolved. Now there are many ways to resolve it. The best way is good rapport on the project with all the team members, and you'll be able to resolve those conflicts before arbitration. We'll talk about that in part 3. Extra work. This needs to be read in relation to paragraph 4. So extra work, the contractor, again, won't acknowledge you're entitled to anything without written authorization. If you do extra work and you did it without written authorization, you may not be paid for it. So be very careful in that regard. It talks about in paragraph 6, inspection and test of equipment. This can be very important, and it talks about all materials and work furnished or performed by the subcontractor shall be subject to final acceptance. If you do your work early in the project, you might have left the project and everything was working fine. But in the final acceptance, is there a problem with what you have done and who caused that problem? This can be a very tight problem for contract administrators, and you have to be aware that there can be abuse of whatever you put in place after you've left the project and before final acceptance. But again, this makes and gives you the burden of responsibility. Paragraph 7, time of performance. Here is a phrase that you'll hear often in the project. Time is of the essence. You will also see that the subcontractor shall indemnify and hold harmless the contractor from and against any penalty or liability incurred by the contractor to the owner because of the subcontractor's failure to perform the work within the time. Again, you need to go back to that variable part, check out time of start, time of completion. Can you do it in that time? If not, you may be the party that's going to be responsible for a delay in the project. Time is of the essence. And although it's here in the boilerplate, it's also understood in all parts of the project. Paragraph 8 deals with extensions of time. Now, if time is of the essence, there may be reasons that you deserve a time for extension. But look at this. It says, failure to give such written notice promptly shall be deemed sufficient reason for a denial of an extension of time by the contractor. So again, if you don't give that written notice, you are going to be swallowing any costs related to the time extension. Paragraph 9, order of the performance of the work. The contractor reserves the right to direct the subcontractor to schedule the order of the performance of the work. What often happens, particularly toward the end of a job, is if you're involved in the end product, you're going to be in there with a whole bunch of other trades trying to finish the job. You're going to be crawling all over each other. So order of performance of the work is going to be the contractor able to tell you just what to do, when to do it. Again, this may not be a good way of running the project from your point of view. So recognize early communication. How should we run this project? How should I get in and get out as quickly as possible? Needs good communication with all parties involved. Removal of debris and waste material. You are going to be responsible for that. Promptly remove all debris and waste material. Now, you notice that nothing was being provided under the material to be provided. Did that mean a dumpster? Was there no project dumpster involved? In which case you're going to, and if you have a lot of debris, you're going to be the one involved in that. These are things that you want to look at and you want to get straightened out well before you get onto the project. Hopefully there is a project dumpster, but maybe not, in which case you've got to provide it. Designation of your superintendent. Generally speaking today, most subcontractors are only providing working foremen. But if this project requires a superintendent, you have to designate who that superintendent is going to be. And then liens and claims. We're going to stop here, but liens and claims will be talked about as a very important issue. It says the subcontractor shall indemnify and save harmless contractor and owner from all claims, liabilities, suits, demands, causes of action, losses, damages, costs, and expenses, including court and attorney's fees. Some of that language may not actually be legal in relation to the laws of the particular state you're working in. However, what it's doing right here is putting you on notice that you're going to have to provide waivers to all of these claims in order to get paid. This is a process that's generally evolved through the construction history, and you're going to have to make allowances for, am I going to give that waiver, which you're going to have to if you're going to get paid, or am I going to put a notice in because there's a claim to be made? Again, rapport, communication, all of these things are important, but notice how this contract is tightening things for you, the subcontractor. And we're dealing with, again, with a subcontractor agreement here, but it also happens if you're the contractor, the construction manager at risk, whatever party you are. The party that has the power, the party that is going to pay the money, is going to give you a tight contract so that they are held harmless. They expect notices from you. We're going to leave it at that, but again, I hope we're starting to see how important it is to read these details. There's the devil. See you next time for part 3.